Hello, everyone. I'm Kevin Gosztola. I'm the managing editor for shadowproof.com, also the curator of the Dissenter newsletter, which you can subscribe to by going to thedissenter.org. And there, it's a free newsletter, and the newsletter covers whistleblower stories, leak prosecutions. Uh, we're following the case against Julian Assange, WikiLeaks founder Julian Assange, extensively. And there are other related press freedom stories as well that we cover. So today I have a video for you with Matthew Russell Lee, a journalist who is his venture is called Inner City Press, and he covers court cases in the Southern District of New York. He also covers the United Nations, and he is based in New York, has been following this case against Joshua Schulte, who is the accused or the alleged Vault 7 leaker. He's accused of releasing these documents to WikiLeaks in 2017 that contained details about the different cyber warfare capabilities that the CIA has at their fingertips, where they can use malware and other tools in an offensive manner to basically wage war against targets. And he is put on his own case. He representing himself. It's the second trial. He was able to survive his first trial. The first trial ended in a mistrial. The jury deadlocked. They did not convict him on the Espionage Act charges that he faces. He's charged with violating the Espionage Act. There's also a charge that was added while he was jailed. They accuse him of using a cell phone and trying to leak information over the phone from prison. Matthew describes some details related to that charge. And so we're waiting now for the closing arguments. The closing arguments in Schulte's trial are scheduled for July 6th. And then, of course, the jury will deliberate on this. And Matthew is the only reporter that has been out there visibly covering this case. If you go to his Twitter account at Inner City Press, you can see the live tweeting he's been doing from the courtroom. This is admirable work. It's the kind of work that I've done on these leak prosecutions under the Espionage Act. And I am sorry that I can't be in New York to cover it, but I'm really glad that somebody like Matthew is there to be our eyes and ears, fighting for court openness, demanding that reporters be able to see the secretive manner in which they're pursuing this prosecution. And here is my conversation with Matthew Russell Lee. So I'm here with Matthew Russell Lee, and his independent venture is Inner City Press, and he's been covering the trial of Joshua Schulte, who is, of course, the accused leaker, accused of leaking the Vault 7 materials to WikiLeaks. And so I'm curious to know how this second trial has been different from the first trial. I know you covered both of those proceedings. That one took place back in 2020, right?
Yeah, in 2020, just before COVID hit New York. This trial, which is almost over, by the way. When we're recording this on July 6th, and both sides have rested their case.
Okay.
So there'll be the closing arguments, and then the jury will get the case. The big difference in the second case, one is that Josh Schulte is representing himself. So that's a difference. Also, the government has chosen to go with a much more streamlined case. I think that in the first trial, as I'm sure you know, there was a mistrial on most counts, certainly on the espionage counts. He was found guilty of misleading an FBI agent, really kind of minor stuff. So I think the government went back and thought about it and said, it's too complicated. It got too much into sort of the interpersonal madness of this unit of the CIA. And so I want to say to their credit, but it may redound to their benefit that they've gone kind of more streamlined. Although today, just now, Josh Schulte didn't testify, but he did put on a case. So he called two CIA witnesses as his witnesses, one of whom, pseudonym Dave, one acknowledged that he himself had made a backup copy of a lot of the files that were to later show up on WikiLeaks. And also that he had taken kind of remote control of Schulte's computer at one point. It may not be as nefarious as it sounds, but I saw some jurors kind of raise their eyes, and it's just in the sense of kind of reasonable doubt. I mean, I think I've been thinking a lot during the trial about, like, Bradley Manning, Snowden, different things. Yeah. And this is different. I mean, Schulte's denying it. He's basically, I mean, he's not, it's a little more nuanced than that, but he's definitely, in representing himself, he's raising reasonable doubts. He's either saying Dave did it, could be, or he's saying you can't prove I did it. And I'm not sure they've proven that he did it. I mean, there's no direct evidence of that. They have a lot of other things. They have a lot of, it's kind of a circumstantial case. The biggest problem for him is that they have other charges against him that they're going to wheel out. However, this case, including they claim to have found child porn on his computer when they raided his apartment. There's another charge in Virginia. So I can't say that the prospects look very good, but in terms of the other charges. But this one, he did a much better job than people thought. I'll be quiet for a second.
Yeah, no, I was interested. I mean, it's interesting. You're raising Chelsea Manning, you're raising Edward Snowden, and we think of these leakers. But in this case, the key to it, and why I remain stunned that there isn't more focus on this Justice Department case, is because they've come back a second time after essentially losing back in 2020. And but part of me does wonder, how do you assess the way in which Joshua Schulte has been able to put on his own defense? Because it seemed like, especially from following your courtroom reporting, that Sabrina Sharaf had done an exceptional job as a public defender for him in that first trial.
I think, I mean, he's done better than people thought he would. He's definitely picked up all the kind of mannerisms and phrases of, like, isn't that correct? And no further questions. I think that Sabrina Sharaf, who I know and respect a lot, he's got, if he chose to go this way, and it is absolutely his right, it's good that he had her as a standby counsel, and I think they spent a lot of time together. It's actually not far from where I'm, with a bad echo, recording this, is a skiff inside the courtroom, inside the courthouse, and they've spent, like, in the first trial now and in between, hundreds of hours, both going over the evidence and in preparing. So I would say, some people said, he's representing himself, he's going to totally flame out. I think he did a pretty good job, and I sort of understand that. I think, like, if you really face spending, honestly, many, many years, if not the rest of your life in jail, you might want to be in charge of your own defense. And I think that there's some of the technical issues, which obviously, no matter how much Sabrina boned up on it, I mean, the only question to me is whether it's lost on the jury. There's a lot of he seems to focus a lot on particular servers and the difference between, various copies of the backups. And I don't think the government did a good job explaining to the jury, and I'm not sure that he did or has to. Yeah. And I think that may have even been part in the first case. There was also, there was a lot of people focused a lot on the sort of Nerf gun wars in the CIA office. But I think it's very hard to prove this case. And or at least let's put it this way. I think the government would admit they don't have direct evidence. They can't say, this is the date, this was the transmission. Because if he did it, and I'm going to say it, I know many people that say, he did it, of course. If he did it, he's very sophisticated. He knows, as people do. I'm going to sort of try to draw you into this. During this case, which I didn't do in the first case, I've been kind of boning up back on, like, I read Snowden's book. I'm reading Barton Gellman's book about Snowden. I've checked out Luke Harding's book. I've listened to an audio book about Chelsea Manning. And in part because I don't understand why there's so less interest in this case, or not just less interest, but kind of less support. Like, my understanding, I did a song over the weekend where I found this I thought it was sort of a video of people building statues of Assange and Snowden and Chelsea Manning in a square in Berlin. And I don't see Josh Schulte on that pantheon, not just that particular pantheon, but just generally. I don't see it. I mean, we'll have a dialogue. You follow this as well. What do you make of that? Why is that?
Well, the other thing that's been really difficult for me is if he's not the one, then should I treat him like he's the person responsible? And there's been a few little tidbits that have come out that, if he's not the person, it might make sense. Because isn't one of the aspects of the case was that apparently he had made some message about believing that. Was it Manning or Snowden should be executed or something like that? What's the offhand comment?
Yeah, absolutely. I think at the time he said that this was terrible leaking. The only thing I want to point out to you on that is, having now kind of immersed myself for the last couple of weeks in all things Snowden, I think Snowden had a similar quote prior to, openly saying that he provided the information to Glenn Greenwald and Laura Poitras. I think he had said that nobody should leak and it's terrible that those books get into great detail about messages Snowden posted on Ars Technica saying that leakers are terrible. So I think you're right, though. I mean, the only thing, and the reason I asked you is because I'm trying to write something longer about it, because I think in part, I mean, maybe it's as obvious as that. Like, people don't rally around him because he hasn't said, I did it and here's why. Somebody wrote to me yesterday and said he's not a whistleblower. The difference is, like, a whistleblower says, I did it and here's why. And if you're put into a position where you're saying, maybe I didn't do it, it's almost like, I don't want to say it's like an OJ thing, but like, so partially his messaging is like, if I did it, like, would it have been justified? Because the things, as we both know, the information that he provided was very useful and very damning or very troubling. That that the CIA was turning Samsung TVs into spying on people. That they were exploiting. These are the affirmative cyber tools used by the CIA. So I think it's a very, if you're a person that believes in privacy, it's a very valuable lead. Maybe it's that he didn't embrace it.
Yeah,
well, maybe there's something. I think it's a different time. I mean, I don't.
Well, and then the other case, so there's a huge difference here, and I got to be fair to the defendant in this case, because there were no child porn charges against this individual. But I think of the Jeffrey Sterling case. I don't know if you've had a chance to look at that. He came and he was prosecuted under the Espionage Act, and he claims he did not leak. He claims he was not responsible. He's a whistleblower in another respect, to a separate extent, but he maintains to this day that he did not release the information, and the Justice Department put on a circumstantial evidence case against him in Alexandria. And so I think of it like this, because it's kind of like with Joshua Schulte. It's like, you're not really proving I did it, and I'm not going to say that I did it, and that's really his only hope to avoid these charges, which, on one hand, actually, if I was in his position, I'd rather be accused of this than the stuff related to the child pornography, because it just seems like it would be a lot easier to So you can comment on any of that, but I did want to make use of the fact that
I just do want to say one thing, because I agree, and I don't want to be dismissive of those charges. I will say that, there's a big range of I haven't seen a lot about those charges. I'm not saying that they made them up out of whole cloth, but I am saying there's an analysis that says he was a computer libertarian that had a virtual machine that he allowed people to post on. I haven't seen what his defense is on that, but I think that maybe that's part of it too. I think you start stacking up these various reasons, but the one thing I'm going to say, I'm accused here within the kind of press community in the courthouse of being too pro Schulte, but I don't know if it's pro Schulte. He's raised a lot of issues about conditions in the first the MCC jail and now the MDC jail that I think are really well placed. I think that there's a broader range. To be very honest with you, in having immersed myself in all things Snowden for the last couple of weeks, along sort of in parallel with the case, I find it a bit too much. I find it a bit too kind of hagiography. I'm not putting it down. Maybe it's because I see the difference. I see like hundreds of thousands of people saying Snowden is a hero. He revealed and uncovered and exposed surveillance. And even if Josh Schulte did it, and even if he's denying doing it, and even if he had images on his computer, if he did it, he revealed a lot too. So I guess it comes down to how much does the motive matter? Is it the result or is it the motive? I mean, I'm saying this as if I know the answer, and I honestly, something is bothering me. So it's driven me to get here before 9 a.m. every day of the trial. I'll put it that way.
So I want to make sure I ask you about actually being there, because that counts for a lot. And I have a couple quick questions for you. So one, can you tell us about what Josh goes through in the morning? He's brought to court. Like, what kind of security does he have to go through? What do you observe as he's participating in the case? And I presume since he's representing himself, he gets to wear
He's wearing a
civilian
suit.
clothes.
He's in a suit. Yeah, he looks. I mean, I also covered the pretrial conferences where he came in his prison uniform. And he's now shaved his head. Before he had sort of longer hair. And I mean, he's apparently he spends a good 5 hours, he claims or says, getting back into the MDC every day. So he's moved. There's no, like, here in this courthouse, a lot of people will stand outside and try to take photographs. There are no photographs of Schulte because he's driven from the MDC into the court. They bring him in early. He's, because he spends a lot of time in the skiff going over documents. I think he knows the documents of the case, extremely well. But I did want to, when you brought up the first case was in front of Judge Crotty, and who's a longtime judge here. He's in senior status. This is Judge Furman's, a younger judge. I can't say that Judge Furman has made this case any less confidential than the first case, which I kind of had hoped he would. Ultimately, there's a sealed courtroom for all the CIA witnesses. Although I did some opposition, and he said 2 pool reporters can go in. So you can go in, but you can't describe. The whole idea seems to be they don't want people to know what these, in some cases, former CIA agents look like. Because it's federal court, unlike Johnny Depp or like Carl Rittenhouse, there's no video of it, and there's also no audio of it. So it's very, my thumbs are getting tired trying to live tweet this thing. It is interesting that for a case this big, I'm right behind you. I'm sitting behind him. Basically, I'll try to describe this to him. He's got his own laptop. All of these things are kind of air gapped, and they're very concerned that he's going to go online. But he's got his own laptop. There's also a computer that runs the exhibits. His standby counsel, Sabrina Shroff, is sitting 4 feet away, passing Post-it notes. And he's questioning, and he's hammering away, and he's within 4 feet of the jury. So it's all very intimate. His parents have been there every day as well. Okay. One other kind of secrecy thing I want to say, I've gotten into it, so I started looking up. They made a big deal as the trial came toward a close of reading from his notebooks. And this is another thing I think that bothers me about the prosecution. I mean, I feel like if you can prove that he did it, or you can prove that he has terrible child porn images, that's it. But when they raided, and also I feel that they set him up with the cell phone charge. Part of the charges here is that while he was in jail, he got a contraband cell phone and was further leaking information from the discovery that he got. I'm not sure they've proved that either. A lot of it seemed to revolve around, he wrote some manuscript called Malware of the Mind, which he gave to his lawyers, writing right on it, attorney-client privilege. But he said he was going to tweet under a variety of kind of comical handles, but he never did. But when they raided his cell to both find the cell phone that they may have kind of set him up on, there's a guy called Carlos Batanzas who's gotten a very good cooperators deal for giving him and another guy called Omar Amanat these cell phones, and then, dropping a dime. There was a 50 FBI agent raid right when I first started coming to cover this courthouse, having been thrown out of the UN. There was an enormous raid. They found the cell phone and they found these journals, and they've been reading the journals, which I mean, I'm a lawyer, so I guess I should say that it's not unconstitutional, but it feels wrong. It feels like if the only way you can prove a crime is to go into somebody's mind in that way, it feels different even than sort of reading their email, right? Because it's a journal. But one of the things they read was, he apparently wrote in his journal, if they don't give me $50 billion, I'm going to blow up American foreign policy and close all the embassies. So when I heard that, I was like, this doesn't sound very good. You look at the jurors, and it's like, it just doesn't sound like a whistleblower when you're talking $50 billion. But of course, it's more complicated than that. Once he was locked up, he filed a civil suit saying, you're treating me unfairly and inhumanly, and you're also costing me future earnings because I'm a computer genius. I think we can say that he's arrogant. I don't think it's a crime. I don't think he should be in jail for being arrogant, but he's extremely proud of his talents and maybe should be. But so he filed a civil case. So I decided to go back and look into it. It's almost all sealed. I mean, like all of his letters, even letters saying that he should get the ability to file a free appeal is sealed. So I filed last night with Judge Furman, and it's assigned to him as well. It doesn't feel right that you lock somebody up, you use their journals against them, and then their attempts to file papers in court get sealed without the government even asking to seal them, just as sort of like it might have secret information in it. So I'm sort of, that's a hodgepodge, but I'm saying, I think maybe even if they feel there's something they don't like about Josh Schulte, or the child porn where it just sets bells ringing, or the fact that he hasn't fessed up, being put on trial with evidence you can't use. He has defense exhibits he can't use in court. And over your journals, there's a lot of kind of due processy things here that I think the trial raises that I kind of wish people had taken more interest in during, and it's not too late. That's why I'm speaking to you from the hallway. It's not too late to sort of, it doesn't, something is afoot. Let's put it that way.
Yeah, it's that gets to my last question to you, was on the openness and transparency of the court. I understand that you've been mounting these fights, and so you just told us about the sealed, the way that the civil complaint was sealed, which is really important. Just to make sure people have this background, it's MCC New York, right? And
he's now in the MDC. The MCC has been closed since Jeffrey Epstein died there, but he's now.
So they moved him out. So they moved him out.
Yes, they did.
I understood initially they weren't going to, because he was pending trial, but they did actually move him out.
Yes, that was actually my scoop, believe it or not. It was everyone reported that the jail was closed, and I found he was like the last guy standing with a light bulb, because the judge said, I don't want him moved right before trial. He's going to lose his legal documents. But ultimately, it's hard to have a single prisoner in an 800-person jail. So they did move him, and everyone is now in MDC. But he followed this case. Go ahead. He filed a civil case.
So just tell us about, like, in general, as far as access to this second trial, what kind of obstacles have you had to deal with that you maybe haven't mentioned yet?
Yeah, when the CIA, I mean, I think it's overblown, honestly, because some of the CIA witnesses, they're not, you having now seen them, I'm not sure I'd recognize them in the street. You know what I mean? They're kind of, it's not, at one point he was going to try to get Mike Pompeo on the stand. This was shot down by the judge. So the guys he got are kind of, and it is very reminiscent of Snowden. Like, one guy was testifying today, a guy whose pseudonym was Chang, single name Chang. And he was there as a contractor. Like, he worked for, and he was also a contractor at the NSA when Snowden was there. Like, I think I saw some jurors like, what, Snowden? They're like, but when they sealed the courtroom, and this is another small point, but I like Judge Furman. I think he's one of the better judges here, but I've had some success in getting, in other cases, things unsealed. In this one, he's really I guess he's a real, national security guy, but the jury doesn't know that the courtroom is sealed, or they might know, but if they know, it's only because they've noticed it. Because every time they seal the courtroom, they send the jury out on some pretext. They say, we're having a technology issue. Can you just step into the jury room? And then soon as they're out, the judge says, okay, everyone that's not authorized by my order, get out. And I thought to the order so I can actually stay in as a pool reporter, but under restrictions of what I can describe about people. Court artists, if there were any there, can't draw them. And then they station 2 court security officers in the hall, and they don't bring the CIA witnesses in until the hall is cleared, quote unquote. There was also this weird order to not go to the floor where the jury has its kind of lunchtime jury room. Under COVID, they want bigger rooms, so they sent them down to another floor. The thing is that floor has other courtrooms where, for example, the Honduran narco traffic cases are taking. So I don't know. He was like, no one involved in this case should go to the 11th floor. And it's like, excuse me, like, I've got to go to the 11th floor. Like, this is not the only trial that I'm covering here. But it's weird. I feel that Judge Furman there was a promise made in his order that because the courtroom was sealed, the public would get access to transcripts kind of on a real-time basis. It hasn't happened. And also, I don't think there's enough recognition by these judges that these documents are expensive. One, transcripts cost even more than 10 cents a page, but even paper is 10 cents a page. So it's not, there's this idea that if you put it on the docket, you've made it public. And it's not, particularly for like a 100-page transcript, that's not really true, you know? I mean, if you get to know the lawyers, maybe you find a way around. So I feel that just overall, because of the lack of cameras in the courtroom, because of the sealed courtroom, it's made it much more secret than it should have been. And I'm hoping to come, whatever the verdict is, to come out with something, a real tear the cover off the ball in short order.
All right. Well, I want to make sure you get back to court. I understand. Is there something
The charging, it's called the charging conference. So it's weird. Each side gets to argue about what the jury will be told tomorrow is the law. And I've put, if you look at @InnerCity Press on Twitter, I just before we went on, I put up the 58-page jury charge. It's a little dry, but it does define what national defense information is, and different things like that.
So let me just take like 30 seconds to a minute here to just mention for those who I do a lot of conversation about the Espionage Act and how it gets charged by Justice Department prosecutors. I noticed that you had a comment about the way they're interpreting closely held. And so essentially they are arguing that if it's released to the public, it doesn't necessarily mean they weren't trying to protect the
That is correct. I was really shocked. That's going to be decided actually just this afternoon. Judge Furman hasn't taken a position yet on that, but the prosecutors have said their argument that they want is that just the fact that it's available to the public doesn't mean that it doesn't qualify as closely held, which is it's a really kind of a troubling interpretation where I mean, here's the biggest irony of this case. The actual Vault 7 publication by WikiLeaks, which can still be found on the internet this moment, was a classified exhibit that he couldn't use. Because the government maintains that if they didn't voluntarily release it, it's highly sensitive, closely held, even if it's everywhere online. So it is a unique, I don't think Judge Furman is going to go with him on that one, frankly. Right. Mostly because I feel like he doesn't, as most judges do, they don't want to create grounds for appeal of a trial they presided over. And I think that would be pushing it a bit too far, you know?
Yeah. I got to ask you something before you run. So when they are making their case, the prosecutors, were there any elements of the documents released that were declassified so they can talk about them in court, or are they just basically saying like document numbers, vague stuff that the jury can't even follow?
Yeah, they really. I was waiting for that. And if there had been, I would rush out of the courthouse and do a vlog about it. I think there were a few things around the edges in the first trial. The second trial has not. It's been very interesting, but not because they've declassified, additional information. That I wouldn't say. It's more
because like what people who know the Assange case, so they've declassified specific documents out of those massive sets. And those are things that they can say things about, like, oh, this involves Syria, or oh, it involved Kazakhstan, or whatever it is that they specifically picked out. But it just occurs to me that for the CIA and these tools, like they really do want to still pretend like they're not known to the entire world.
Yeah, I agree. Exactly. Because I remember that too. I think like the diplomatic cables are one thing. And like these tools are something else, and so I feel that they feel the less said about them, the better,
All right.
And they sort of, so I mean, and the other difficulty here is I want to say this because in some cases here in the Southern District, the prosecutors make their exhibits available. Like I'm covering the OneCoin case; it's a cryptocurrency case. They very proudly put online like the final email of Ruja Ignatova, and they put it on a sort of a file sharing site where the press corps can get it. You're supposed to write a story that she's on the 10 most wanted list. But this trial, they haven't made any of these. So even the exhibits that are not sealed are not really available. You're sitting there and they flash on a screen, but it's not like you can get them. And when you ask for them, I've had the experience where I have to do a FOIA request for exhibits used by the prosecution in open court. And I think that this is something where Congress, in the same way that like PACER fees, these might be a little too inside baseball for you, but I think there are a lot of improvements in terms of court transparency that really need to be made. And one of them should be that exhibits used in criminal prosecutions, you shouldn't have to do a FOIA request and wait a year. It's not fair to the defendant either.
All right. So again, thank you, Matthew, for your time. I pulled him away, and he had to get back to hear the court discuss and deliberate over the instructions they're going to give to the jury related to the charges that Joshua Schulte faces, which can be mundane, but as we've seen with cases like the Kyle Rittenhouse case and others, what the jury is told about the charges can make a difference in how they determine whether that person is guilty or not. And so they're going to hear those instructions and then they'll go, and it could take a day, could take 2 days. We'll see if they acquit him or they deadlock. Maybe they're not able to agree. But no matter what, when we have the outcome, I plan to talk with Matthew again and to post a video to cover the outcome of this important case, because whatever happens is going to be a kind of precedent as far as Espionage Act prosecutions go. And this is one in which the U.S. Justice Department has uncharacteristically had to struggle. And if they lose, there's no guarantee that they don't try a third or a fourth time, but maybe they will be done. Maybe they'll settle for going after Joshua on these other charges that he faces that have nothing to do with the Vault 7 materials, but do kind of relate, because I think the the charges stem from FBI investigating Joshua Schulte when he became a person of interest, someone they suspected of being the alleged leaker. But obviously, we know that these cases stack upon each other. These Espionage Act precedents, one informs the other until they snowball and give the prosecutors the uh, belief that they could go after someone who's a publisher and not just somebody who is a government contractor or a federal government employee at the National Security Agency or the CIA or any other part of the US government that has access to classified information. So, with that, thank you for tuning in. I will be back soon with some more videos, but until that time, I encourage you to go to thedissenter.org, become a subscriber if you are not already, and follow these types of stories. Also, hit the like button and also subscribe to this channel so you can know when future videos like the interview with Matthew are being posted.